Okay. So as I have, I think, made pretty clear, I am somewhat frustrated by the idea that there are 4 defendants and none of them are somehow responsible for producing documents, despite the fact that some documents have been produced. And clearly there are people whose job it is to receive these requests and process these requests and attempt to secure discovery. I'm sorry, attempt to secure requests, the responsive information. So here's what I am left with. Again, I will say how much I would love it if the Supreme Court had given me the answer, because as it stands, I'm going to give you the answer I think is appropriate, and the Supreme Court may tell me I'm wrong in any moment. So, there's that to look forward to. Having said all of that, I think I've made very clear, I understand the effort at the distinction, but I struggle to see how Fani Willis individually is an appropriate defendant here, because she was not served. I understand that she received internally probably requests. She was not served with a formal request for records that she was in possession of, other than to the extent that the Fulton County DA was served with a request. And so I have real concerns about that. And I understand the import because of the concern about immunity that potentially attaches to Madam DA Fani Willis. But I think there's a distinction for a reason. And so I am going to grant the motion to dismiss Fani Willis in her individual capacity. Having said that, however, I am denying the motion to dismiss Fani Willis as the DA, and I'm denying the motion to dismiss the Fulton County District Attorney's Office, and here's why. Number one, as to Madam DA Willis, the district attorney, I agree, has some broad immunity that attaches. But I agree with the plaintiffs that the traditional understanding of immunity that attaches to a district attorney was not intended to limit or inhibit the public's right to access non-prosecutorial documents, non-investigative documents that are held by the district attorney.
There's nothing more powerful than the odor of mendacity.
All right, welcome back Inside the Law, everyone. I'm your host, Philip Holloway. This is, of course, the LawTube channel where we take you inside the real legal system, the real justice system. We show you what it's really like, not how you might think it exists if you just get your information from cable news or even watching the movies. So we do this in the context, as you know, of real cases, real controversies, things that are actually pending in courts around the world, or the country at least. Now, what we just saw, this is a ruling from a hearing. There was a civil lawsuit filed by a lawyer you might have heard of. Her name is Ashleigh Merchant. In fact, the plaintiff in that case is the Merchant Law Firm PC. So she and her law partner, husband John, they own the practice. And so they filed some open records requests as part of Ashleigh Merchant's endeavor to uncover how the Fulton County DA's office and Fani Willis has sort of set up, how they investigated, how they prosecute, and the Trump RICO case. Okay. And so there's this dispute because under Georgia's law, when an agency or a county, in this case, the county government if they don't produce the documents that you're entitled to within a certain period of time, it's like 3 days, then the law gives you the right to bring a lawsuit. So what is this all about? Well, the lawsuit is not over. There's not a trial yet, although it's been scheduled, I think, for a final hearing date on this, but this was a motion to dismiss. For reasons that we're going to get into here in just a minute, we're going to see that Fulton County and the district attorney's office has asked for that judge, Judge Krause, to be recused from the case. They're trying to get her booted off the case. Why? Well, that's a really good question that I really can't answer, but I tell you what, in order to help me answer it, I want to welcome our panel today. These are our friends. Let's give a big round of applause to friends of the show, legal warriors, both in their own right, my friends and my colleagues, attorneys Rachel Kaufman and YSL Doug Weinstein. Rachel and Doug, good afternoon.
Good afternoon, Phil.
Hello.
So I don't know if you guys, I saw you in the waiting area there. I don't know if you saw all of that ruling, but I know that you've looked at this pleading, and we're going to get to that in just a minute. But before, well, let's just get into that. So first off, guys, what did you think about the judge's ruling? And I've got more of it, and I can bring it back up, and we can play it, and we can dissect it. But before we get into the actual motion to recuse, which Doug, by the way, is an expert on, because we all saw him go through this with the YSL case and the former judge in the case. In fact, it was Judge Krause who I think recused Judge Glanville, right, Doug? So
that's
you've got
that's exactly right. So
maybe there's some payback here.
There.
Yeah, maybe there's some payback here. What did you guys think about the judge's ruling just from the snippet we just played?
I'll let you go first, Doug, if you'd like.
Sure. Yeah, I have to honestly tell you, because I was so focused on the motion to recuse and the way that it's drafted, honestly, her ruling doesn't even matter that much for their motion. So, I've read a little bit before, and I've watched what you played, and it seems to have made sense. There's a legal basis for it, but, obviously their issue is they don't agree with the ruling.
Well, and so what I want to, if we really get to the root of what's going on here, this is a lawsuit filed by the merchant firm as the result of an open records request, which I'll kind of explain what that is. An open records request is when, the public can ask their government for documents relating to things that legally the public has a right to. And so this entire lawsuit is really the result of Fulton County and the Fulton County DA's office not responding and not producing documents that the merchant firm requested through an open records request. They were requesting specifically, my understanding, are documents related to the amount of money that Fani, Willis, and the DA's office spent for media review, for basically media tracking, to track the success of her media campaign in the Trump prosecution. The fact that this is all having to happen, that they're trying to, that the prosecutor's office and the Fulton County are spending these kind of resources trying to defend their refusal to turn over documents that the public has access to is truly insane. It makes you wonder, and actually, you can tell the story without even having the records produced. Clearly, she spent a lot of money on the media, on these media consultants. Otherwise, she wouldn't be fighting it. And so
that's exactly right.
That's what this is about, and it's just unbelievable to me that they went as far as to say that the judge should be recused because the judge said that they have to produce the records.
Yeah, well, so, right, and to touch on that, so as Michael Lawless points out in the chat, some of the records that they were going after is records pertaining to this company called Critical Mention. And so right around the time that Willis brought the racketeering case against former President Trump and the others, she hired at county expense this media tracking company, like Rachel pointed out. The way I've put it, when I've done other shows and streams about this, I call it she's basically using taxpayer dollars to track how her media star rises, how successful it is, and how much good publicity she's getting. Doug?
That's a whole different issue than the recusal, but I'm happy to slam on her for this sum. What in the world is the DA's office doing, spending public money trying to see the media reaction and the public reaction to her taking action against former President Trump or others. I'll leave the others to the imagination of your viewers for now. But what does that have to do with your duties as a prosecutor in bringing actions before the grand jury, in seeking indictments, in prosecuting cases? It is irrelevant. And to spend public money testing this out is outrageous.
And then when they request it, and then when the public requests to find out the amount of money that you're spending, you act like you're above the law, and like Fulton County doesn't have to turn those things over. Given that it came from taxpayer dollars, it just seems really bizarre that they would go to these lengths in an attempt to hide that kind of information. If you have nothing to hide, just produce it.
And again, it's part of the lack of transparency that we are constantly seeing out of this DA's office, whether it's failure to provide Brady material or hiding this type of information. If what you are doing in this, it's not really polling, but in this, paying these folks for looking at your media and looking at public perception of what you're doing, if what you're doing is okay, why are you concerned about handing it over? Oh, why are you so hesitant?
Yeah.
Why aren't you proud of it?
Yeah, no.
Look what we're doing. It's your DA's office. Look at this great job. We're polling information. We're getting information on how we're doing with you guys. Isn't that a great use of taxpayer money?
And then to flip it on the judge just feels complete. It's like when you're, I've talked about this before, but like when you're being accused of something, you just automatically start like placing blame everywhere else. And in this case, and I think as we'll discuss with this motion to recuse, I mean, it is truly baseless.
It is utterly baseless.
Yeah.
Absolutely, Rachel.
Like I don't know what planet they clearly haven't been defense attorneys, because if I asked every judge who's denied a motion of mine to recuse themselves, I mean, that's a crazy thing to do, especially given how many cases are before that judge. It's like intimidation, and I find it really problematic.
For you guys that watched YSL, and I know we'll get into this, but for you guys that watched YSL, when I stood up before Judge Glanville, Chief Judge Glanville, on June the 12th, and said, you should recuse yourself, and here are the reasons why. You violated these canons, you violated this, you violated that. His initial response is, Mr. Weinstein, you're just complaining because you don't like the way I ruled, which is actually what the DA is doing right here.
Right.
But that was Glanville's position. You're complaining because you didn't like the way I ruled.
Yep.
I never complained about the way he ruled. There was no complaint about the way he ruled, but that is exactly, and I really have no idea what the attorneys who wrote this motion for recusal were thinking.
They were thinking,
because they cite the law properly, honestly.
Well, so let's just get into what the law is, and then we'll get into this motion. Doug, that's when I saw this, you're one of the first people I thought about, because I remember very clearly that exchange between you and Chief Judge Glanville, where he said, you can't file a motion to recuse a judge just because you don't like how the judge rules. And he's correct. You can't do that.
He's absolutely correct.
That's not what you were doing, by the way, but his statement was technically true in that sense. So, all right. So let's just, Rachel, feel free to chime in as well. But Doug, I wanted to let you start out by educating or reminding those of us who may have covered this before, and I know we all did, those of you who have been with us here inside the law for some time, you remember that we've discussed this at length in the context of the YSL recusal, which is why we have a new judge there now, because of, all the lawyers did great, but Doug, you're the one that took it to the Supreme Court that really got this thing kickstarted. So let's start off, Doug. Remind us, refresh our memory, what it takes in Georgia to get a judge recused, booted off a case.
Sure. So to get a judge booted off a case, you've got to seek recusal by a motion for recusal. It has to be filed in a timely fashion. I believe there's a 5-day time limit. You have to have an affidavit that has facts that would support recusal. And then the third part is you look at that affidavit and you say, if those facts would support recusal, the judge has got to kick that issue of recusal off to a separate judge in order to decide whether he should be recused. But, they cite the King case here, which is the right case. There must be some appearance of impropriety, whether that impropriety is, you can see where they cite the King case here, whether that appearance of impropriety is violations of judicial codes of conduct, violations of some type of rules that govern the practice, civil procedure, criminal procedure. So you need some type of a violation there. And there's no, in this brief, there's no real allegation. As a matter of fact, and I think, Phil, you highlighted this portion in a tweet at one point, but they don't even pretend there's been an appearance of impropriety. They just basically say the issue, what you did wrong, was to rule against us.
All right.
And they spent 147 pages thinking that they could just make it look like, because we have a large quantity of pages, that somehow we have some sort of proof. It's like 147 pages of nonsense. And that, again, we have Fulton County taxpayers paying for Fulton County attorneys to be writing these motions instead of doing what they're supposed to do in their office, like maybe just hand over the documents.
All right, so let's go through this.
Hours to write this 6-page motion.
By the way, we're not going to go through 147 pages. Everybody will be happy to know. We don't need to. The first part of it is really what's relevant, and then of course the affidavit. And I want you guys to interrupt me, stop me. I'm looking at a different screen, so I can't see Rachel and Doug right this minute, but I can hear you. And if you want to interrupt me, by all means, please do so. But I wanted to just take a look at this. We've got the merchant law firm as the plaintiff. I think they left off PC. They should have put, because they're a professional corporation. But anyway, this was drafted by some attorneys who work for the county attorney's office. So let's be clear, this was not filed by lawyers who are employed by the DA's office. These weren't like assistant DAs, but in this case, the county attorney's office is representing Willis in the DA's office. So they've called this the defendant's motion for recusal of Judge Rachel Krause and a motion to stay the proceedings. So, Doug, you were talking about the requirements for recusal, which in order to get a judge recused, you've got to demonstrate what the law is on the case. And we have what's called Superior Court rules, and they correctly point out that the affiant, which is the individual who is going to submit an affidavit under oath. This would be an individual. Sometimes it's a lawyer, sometimes it's not. But it's an individual who supposedly has personal knowledge of some fact or facts that indicate the judge has done something to call his or her partiality into question, right? And it has to be done quickly. There's a 5-day trigger, right, Doug? So that's why we saw in YSL you guys doing this so quickly, right?
That's exactly right. You have to move fast. So.
And so,
but look at the part. How did they learn of the basis for the disqualification? I think this is what you highlighted, Phil. What is the basis for disqualification? Well, the basis is right there near your mouse pointer.
The judge's order.
It's where they learned that the court was going to dismiss, not going to dismiss.
That's right. I highlighted
claims.
The defense counsel first learned of the grounds for disqualification on September 5th, which was, by the way, I did a live stream that day. I streamed this whole thing. And of course, the ruling sort of came at the end. And so what they're saying is that they first learned that these alleged grounds for disqualification came into existence on September 5th when the defendant, that's the county and the DA's office, should be defendants plural, but what's being accurate anymore. It's a little sloppy, but the defendants learned that this court, Judge Krause, was not going to dismiss plaintiff's claims. That's what the hearing was. It was a motion to dismiss. We call it a 12B6, motion to dismiss for failure to state a claim, right, Doug, or something like that?
Yeah, 12B6.
12B6 motion to dismiss the claims against the defendants, despite what they say is well-established law. And I'm not so sure that it is all that well-established, but nevertheless, that was what they were arguing. And if you're interested in watching that, it's 2 or 3 hours and it's on this channel. You can go back and watch the whole thing. but they were arguing, Judge, you need to dismiss the plaintiff's claim because it's contrary to the law. And so because the judge has ruled against them, they say that the defendant's motion is therefore timely.
I'll give them that. I think they're right that the motion is timely.
I give them that much.
They
I
checked
agree.
the box on 25.1. I'm 100% with them on that.
They say the Supreme Court has established the recusal standard, which is, and they get this right, it's to avoid impropriety and the appearance of impropriety in all their activities and to perform the duties of judicial office impartially and diligently. So far, that's correct. They have correctly stated that. They again point out here where impartiality might reasonably question. Now, so let's talk about this for a minute, guys. When we talk about things that are subjective in nature, it's like if I think that Rachel's playing her music too loud, that's a subjective opinion. Doug might love it that loud, and he doesn't think it's all that loud. Now, so that's just something that exists in my brain subjectively. 2 + 2 is 4. We can objectively do the math on that, and it's always going to objectively be proven. You can take an x-ray of a broken leg, and that's objective evidence that the leg is broken. So here we have this standard where impartiality might reasonably be questioned. Now that's the gray area, which exists all over the law, of course, but this is why they are saying that she's that her impartiality could reasonably be questioned. Doug and Rachel, did you guys see anything in her ruling or anything in that hearing that you think would reasonably question her?
No, and it would have to look like you're being very disparaging to one party and not the other on the record, which is what happened with Glanville when he was saying that specific lawyers were not prepared and they're not professional. And then he tried to hold at least one of them in contempt for not telling him who told them about his ex parte meeting with the state and Kenneth Copeland.
Right.
All they point to is that in this case, my understanding is that the judge that she gets on the record and she's basically like, I don't understand how you could have 4 different, Fulton County entities and agencies and none of you are going to turn this over. That's just the truth.
Yeah.
So I played the first part of this ruling. I'm going to go back to the motion. I want to get just a little bit more sound. This is Judge Krause when she's delivering her rulings, and we can pause. Your microphones will be open. So if you want me to stop, just let me know.
The traditional understanding of immunity that attaches to a district attorney was not intended to limit or inhibit the public's right to access non-prosecutorial documents, non-investigative documents that are held by the district attorney. And I think that if the legislature had intended so, it would have exempted district attorneys generally, and it did not. And so for that reason, I'm going to deny the motion the motion to dismiss as to District Attorney Willis. I am also going to deny the motion as to the Fulton County District Attorney's Office. And I do that with the most hesitance because clearly the Fulton County District Attorney's Office is not a legal entity that can be sued in any capacity. However, I don't think there's any way to read the Open Meetings Act provisions that are adopted by reference in the Open Records Act provisions without understanding that the Fulton County District Attorney's Office is an office, agency, department, et cetera, of Fulton County or of the state, and therefore would be subject to the Open Records Act.
So let me just pause for a second. And I think, and y'all, the way I see it, what she's explaining, and I think correctly so, constitutional officers like DAs have a lot of immunity, and it may be generally true that you can't just sue the DA's office as an entity. If they engage in prosecutorial misconduct, that's more like a personal kind of a tort. But in any event, or a cause of action, we would say. But the Open Records Act clearly applies to district attorneys and their offices, and Georgia's open records law clearly, by statute, creates this civil, we call it a cause of action, a civil claim that you can make when they violate it. So the judge is trying to square those two things. The county is saying, well, you can't sue the DA's office, but the Open Records Act clearly applies to them. So the judge is trying to make that distinction. That's how I see it.
Yeah, and they're not asking for money from the DA's. I mean, this is not a typical lawsuit. This is just getting them to enforce the Open Records Act against a county agency. It's very simple.
But I think the most important thing that your viewers should watch as they view this is you're not looking at this. They should not be viewing this as, is she right? Is she wrong? Maybe should this be appealed? Did she make a improper decision on the law? Was it not rationally based? You can talk about all of that, and maybe you could even disagree with her. Maybe you could say, well, I don't know that the Open Records Act should apply to the DA's office since they're not an entity capable of being sued. I don't agree with her conclusion there. But if that's the case, the proper remedy is at some point some type of appeal. It is not. Did anyone see anything there that would lead you to believe that there's an appearance of impropriety? And that is the standard. Again, in the brief, the legal section of the brief is correct. It's the application that's the issue.
So let's see what else she has to say here.
Requirements. As to Fulton County, I do have concerns, as Ms. Monroe pointed out, that any ruling that I make be understood as overly broad, in the sense that any request submitted to any department of Fulton County using its portal somehow makes the entirety of Fulton County responsible. And that is definitely not going to be my ruling.
So there she's saying that she's not going to hold the county broadly, sort of liable in this. So, Rachel, you filed open records in Fulton County, haven't you? Tell us about this portal that they're talking about.
Okay, so basically, in my understanding, having listened to some of the argument by John Merchant, Ashleigh's husband, is that they had a lawsuit maybe 10, 15 years ago where there was an issue where I guess other agencies or like offshoots of Fulton County were claiming that they didn't know that the Fulton County government or whoever had provided the open records documents had actually provided them, and they weren't supposed to provide them. So they created this like centralized portal where you have to like sign up, and all open records requests regarding Fulton County related things have to go through this online portal. And my understanding is that from there, there's supposed to be an open records administrator or someone whose job it is to kind of then figure out from there which specific, whether it has to go to the tax commissioner or the DA's office, or which entity of Fulton County is supposed to handle it. And then in order to produce the records, it has to go through the county attorney's office.
Yeah, Doug, you can see, can't you, how this is something that it easily could the train could come off the tracks, because if the county has this portal and you have to go through that's the established mechanism for getting these records that you're entitled to by law from any county agency, whether it's the dog catcher, the DA, or the sheriff, or whoever, right? Yeah. You got to go through this portal, and so it's easy to say, "Oh, it's not my job; it's somebody else."
Oh, and that's what they'll do. They'll tell you. They'll say, well, we don't have those records. You'll have to send it to this agency, but it's all through the same portal. So you just spend a lot of time going back and forth with whoever the administrator is or whoever. I've dealt with this a lot, trying to get things from the jail. They will find ways to try to avoid giving it to you, or tell you that they don't have it, or tell you that you haven't provided them with the right things, even though you have. It's really a way of creating kind of like a traffic jam for the public to get access to open records that they're legally allowed to request and get within a timely manner. And so again, all that's being asked of the county right now in relation to this lawsuit is to hand over specific documents that the public, including the Merchant law firm, are legally allowed to have.
All right. So she's almost finished.
Thanks, Rachel. I always learn something from you, Rachel.
Yeah. Okay. Rachel, I mean, see, you two brave the Fulton County elements, and you're braver warriors than I am. So that's why I lean on you guys for the specifics of Fulton County, because it's not for the faint of heart. Let's see what else the judge has to say.
However, to the extent that Fulton County hosts the portal and is clearly subject to the Open Records Act, particularly here where the agency and the officer are denying that they are subject to the act. The county clearly is, and the county is hosting the method to request and receive responses, to submit requests and receive responses and responsive documents. And so to the extent that the county is doing so in the absence of the records custodian, i.e. the district attorney in her official capacity, or the Fulton County District Attorney's Office, such as it is constituted for purposes of it being an agency or office, Fulton County stays in the case as well. So that's going to be my ruling. I am, as I said, I'm granting the motion to dismiss as to Ms. Fani Willis. I'm denying the motion as to the other defendants.
All right. So
yeah, that makes sense. That makes sense. She's saying that if she disqualifies one of them, she's concerned that they'll be able to say that they no longer have the records custodian, so Fulton County won't be able to turn it over. Since none of these entities are taking responsibility for getting these records to the merchant law firm, she's keeping them all in the lawsuit. Very simple. And none of that is wrong, and none of that presents the appearance of impropriety. She's just saying, somebody turn over these records. That's it.
And none of that is, I agree completely with Rachel. And by the way, well, I'll wait till you get to the rest of the DQ motion, the motion to recuse.
Anytime you want to feel free to speak up, buddy. Anytime. All right. So we've all kind of agreed now that that they get the legal standard right. They go on to point here that the Superior Court rules require that another judge to hear the motion. And Doug, remember when Judge Glanville refused for like 2 weeks, right after he refused to send it to another judge. And so what has to happen, folks? If the affidavit on its face, whether it's, you don't have to prove that it's true, but accepting the affidavit as 100% true, if that states sufficient grounds to believe a judge might be, at least have the appearance of being less than impartial, then they have to send it to another judge to actually hear the actual contested motion. Because, if I'm the judge and you want to boot me from the case and you're saying it's because something I've done, I might not be the best person to judge my own conduct. We need to have a third party make the call on that. So
that's right. That's consistent. Yeah. And that's consistent with the rules of recusal, not just in Georgia, but in federal court as well. And again, they have cited the law correctly. It just doesn't apply to what they're alleging.
Judge shopping. And that's like what we tell. I mean, sometimes we're in front of a judge who's, a former prosecutor who maybe I would prefer would not be the judge. Just because I don't like the judge, or just because I think that the judge, maybe even just, biased without the appearance of impropriety, but I know how they rule. I don't get to file motions to recuse them and then get another judge to rule on it. This would literally, clog the docket even more than it's already clogged, just in order for people to go judge shopping. They don't like the judge ruling, so now they're trying to get a different judge, and it just doesn't make any sense in this context at all.
Right. And if you look at the synopsis of facts warranting recusal, it reads like a bland recitation of the procedural history of the case.
Exactly.
And as I read through this, I'm constantly looking, as I read it, where's even an appearance of impropriety in any of the actions that the judge took. Yep. And I can't find one. I can't even find an allegation of one.
Well, I mean, here it is. They say they give when the date the lawsuit was filed, and on March 13th, they did an answer to the lawsuit. Then there was an amended complaint. There was hearing. This is all standard stuff that you see in all kinds of civil cases, right?
Yeah.
And so they go on to say here that the defendants were then forced to file answers. Well, of course, that's how lawsuits work, people.
Woo-hoo.
Oh my gosh.
Yep. So they say here, and the reason I highlighted this, they make this allegation here that Fulton never received the open records request at issue. So what I'm going to do is I want to bring up, I want to add to, it would take me a second to find it. So if y'all got something to say, now would be a good time. But I'm going to try to bring up the actual lawsuit so we can, because there's some exhibits to the actual lawsuit that are relevant to that.
I can tell you that, when they make comments like that, like Fulton County didn't get it, Fani Willis didn't get it, it all goes through the same portal. They all got it. It's very, again, that's the point of the portal.
Defer to Rachel on that because of her experience, but I'm sure she's right.
You can't just not get it. They all had access to it. Clearly, the attorneys are in the middle of it. They know they've received it. If I tell you now that I want the open records request to be fulfilled on the record in front of Judge Krause, are you now going to hand it over? My guess is no. Again, because now you just want her recused. It doesn't sound like the issue is whether you got notice of the request. So please.
Right. So here is the plaintiff's complaint. Now it's 108 pages, and again, this is the actual lawsuit that was filed. Okay, and I've on another video I went through all of this and we talked all about it. So if you want to go check that out and read for our analysis of the entire lawsuit, you can do that. But I bring it back up today because they have attached as an exhibit here to this lawsuit, they have attached all of the open records requests that go through this public records center, right? This is the portal. And they're saying that they don't have, they're alleging in this, look, it's all about Nathan Wade, right? So,
part of it.
So it's clearly a lot of stuff, and she's got.
Yeah, they ask you what you're requesting. Go up a little bit because they ask you what type of records are you requesting, and if you said the type of record or I'm not sure, go up a little bit. You can select the department. If you don't know which department is going to be in control of it, you can write I'm not sure, and that's why you describe the records that you request, and they're supposed to send it to the right department.
And I'm sure I'm not sure is the right answer to put there, right, Rachel? Because if you name a specific department and you name the wrong one, you will likely get nothing. The goal would be that if you send it to a specific department and they don't have the records, they should let you know they don't have them and try this department. But yeah, if you're not sure, you should just write not sure, and they're supposed to farm it out.
I mean, so they're saying in this pleading that that the county doesn't have the open records request. I don't understand that. Maybe I'm misreading it, but I'm looking at emails going back. This is September of 2023. This shows you. So Ashleigh broke this groundbreaking news, I guess earlier in 2024, but you can see as early as September, she was laying the groundwork for it. And so we've got more exhibits. These are all the open records requests. So she's attached these to the lawsuit, and for them to say that they don't have them is just, to me, it's just stunning. I don't understand.
And Judge Krause would have never ruled the way she did if they didn't have them. It's that
of course
simple.
Not.
Just to think, and I think John Merchant mentioned this when he was arguing too. I mean, you have a law firm asking, making this open records request. They have the persistence and diligence and understanding about how they actually need to proceed to get these records. Usually, the average person would think and should be able to think that when you file an open records request through the portal, that you shouldn't have to go back and forth with some records custodian for months and months and months to get what you asked for, and then have to file a lawsuit. There are no open records when you're having to do things like this. And just the fact that most people, this is a law, like you're supposed to be able to get them. So it just makes no sense that they've had to go through pulling teeth, literally pulling teeth, trying to get records out of Fulton County that owes the public transparency through these records. Period.
They go on to say, this is all what they call the factual basis for the recusal. The court had an evidentiary hearing on September 25th. They even quoted the judge. She says, I'm somewhat frustrated by the idea there are 4 defendants and none of them are somehow responsible for producing documents. Doug and Rachel and anybody in the chat, can you please help me understand how that statement, besides the fact that it's absolutely understandable and reasonable, how is that supposed to show that the judge is something less than impartial?
The closest thing they come to me, you can keep this page up there. The closest thing they come to me of showing or even pretending to show some type of appearance of impropriety is the last paragraph here, where they say the logic that, and I disagree with this, by the way, but they say the logic that applies to dismissing DA Willis in her personal capacity should also apply to dismissing the other parties sued. Two things about that. One, I don't agree with it. But second, it's a legal argument to be made for some type of appeal. Maybe a writ of mandamus, or probably not. But this is nothing to do with recusal. This is a temper tantrum, likely drafted by, and I'm gonna try to give the benefit of the doubt to the attorneys who had to put their name on this and draft this. I am going to assume that they have bosses like many of us have, and their boss told them to do this, and they did the best they could with a totally piece of shit, excuse my language, argument.
This is why I cannot have a boss, because you know what? I mean, their names are attached to this, and they still have ethical obligations and professional responsibilities. And for them to just, be yes men to people who want to play games, it just feels like they deserve to go down for it too.
I totally get it.
I mean, it's like a doctor, like, do this surgery. It's like, I'm not going to do the surgery. It's not the right thing to do. And it's like, do it anyways. I mean, if I have any ethical integrity, I'm going to say no.
I know, but I give people the benefit of the doubt until they absolutely break me.
Like, that's so nice of you, Doug.
I empathize with people, and I don't know, it's not like they can maybe stand up and quit. Maybe they've got families to feed. I mean, you know what people are going through. But I will say, what a piece of crap this is. Just
it's an embarrassing thing to sign your name.
I would be embarrassed, and I have to tell you something. I have been in a position before where I've had a bad or difficult boss, sociopathic boss, who's had me draft things, and I'll tell you what I've done. I've drafted them, but then I have said I will not put my name on it. I'll draft this for you. I'll do all the legal legwork. I'll do the best I can, but I'm really not comfortable putting my name on this.
Have some integrity.
You signed the damn thing.
You signed it. You want to do it so bad. That's essentially what you're saying.
All right, well, their grand finale here.
I think what I really have to emphasize.
Yes.
I'm sorry. Emphasize, my speech impediment from my youth is coming back. I think I have to emphasize how there is truly no allegation of impropriety in the basis for the recusal that they had. They don't even really allege one. You cannot find a sentence that says, here is why the judge acted with impropriety, or here is where the appearance of impropriety is. And it's because there isn't one.
Well, the grand finale here of this is the last part of their pleading that even would apply. It says the court dismissed DA Willis in her individual capacity. That the fact that she dismissed her in her individual capacity ought to be evidence that she is being fair and impartial, right? She granted their motion in part. She didn't completely deny it.
Well, the best they could say is, oh, that's just the judge splitting the baby for appearance purposes. And even then, that's more of an appellate argument and not one for recusal. By the way, Ashleigh and John Merchant are going to eat this brief alive.
Oh, I can't wait for the response to pleading.
I wish I could write the response to this. I would
certainly could use the help. Well,
no, they don't need my help, but I would have such a good time with it that I'm jealous that I won't get to draft the response.
All right, in a minute, I want to explore the affidavit here of attorney Brad Bowman in support of their motion, because as we've discussed, there must be by law an affidavit attached, right? But before we do that,
let me add something else. I'm going to interject and jump in on you, even though this is your show. Other thing is they're required, and I don't know if they did this. As far as I know, they didn't do it, but they're required to present this to the judge. They have to actually, under our rules, and that's what was incredibly uncomfortable that I had to do with Chief Judge Glanville. I had to go up to him in court and present him with this. You can't just serve it. Or maybe you could argue service is presentment. I don't know. As far as I know, they didn't present this to Judge Krause, but then they're skipping over that part. I'm sorry. Go ahead. I'm done now. I just wanted one more opportunity to take a pot shot.
And Bowman is one of the attorneys who signed this pleading. So he is also the person who is signing the affidavit.
We're going to get into
that's not unusual, right? That's not unusual.
We're going to get into that affidavit. Yeah. I want to briefly switch gears to another sort of topic affecting the district attorney's office. And I don't want to spend more than 3 or 4 or 5 minutes on it, but I wanted to get your thoughts on this before we get into the affidavit. Have a look.
The last person on our agenda, of course, is the first person, Honorable Fani Willis. She has not appeared yet. I would ask the doorman, please check the hall to see if she has appeared before we adjourn.
Mr. Chairman.
Yeah. All right, thank you. Then let's please note for the record that Ms. Willis has failed to appear in compliance with the subpoena and has failed to produce the documents requested by our subpoena for the production of documents.
All right. So this is I showed that because it's related, because they too, that's the Georgia Senate. I streamed this yesterday. That was a clip from this show here Inside the Law, the last couple of minutes, where they actually went outside and get one last look. They sent somebody to make sure she wasn't hanging around in the hallway somewhere, because they had subpoenaed her, not just for her testimony, but they also are trying to get these documents. It's a different route, but the Georgia Senate had subpoenaed her. Now, I would point out, before you guys weigh in, let me just get this out there so we got the whole picture. She being Willis has retained former Georgia Governor Roy Barnes, who's a great lawyer, to represent her, and she's filed a motion to quash that subpoena. And it's my understanding that every judge in Fulton County recused his or herself. Okay, here we're talking about a different kind of recusal, but again, it's kind of related. They have recused themselves voluntarily. Nobody had to file a motion. So they were looking, last I checked, for another judge in another county somewhere who could hear it. But as of yesterday at 11:30 or so in the morning here in Atlanta local time, that subpoena was still out there and it hadn't been ruled on. So they just decided not to show up. So I'm really not talking about the validity of the subpoena, but I want to get you guys to weigh in on the Herculean efforts that Willis is undertaking to avoid handing over all these kinds of documents and records.
Yeah, what documents and records are we talking about? We're talking about documents and records related to her hiring Nathan Wade, who she clearly had a relationship with, paying him more than $700,000, claiming that under oath, in front of Judge McAfee, claiming that she paid Nathan Wade back for the several trips that they took, that she paid him back in cash. There's no record of that. The only thing that she's being subpoenaed to talk about are allegations against her that, that she was acting without integrity. And the fact that she's running from it is so telling to me. Again, it's the same thing that's happening with, with her not wanting to turn over these open records about this media consultant. The answer is clear. She doesn't have a good answer for any of it, and that's why it isn't being turned over.
Yeah. And Phil, thank you for asking that question and not the question I thought you were going to ask, because now I get to serve this big fat softball up to Rachel.
Okay.
Rachel, in all of your experience with the Fulton County DA's office, what do they do with folks that do not show up to court?
Perfect.
When they are supposed to be at court, or they
look at the softball. I still want to get the softball too. Go ahead.
What would the prosecutor do right then with the judge?
A material witnessed arrest warrant, and they will throw you in Rice Street, which is the jail, until they bring you before a judge.
Or you get a bench warrant for an FTA, or
you don't just not respond to a subpoena. Her office would lose their minds over this, and we have this happening right now. We have somebody who's now sitting in jail because her office didn't think that he would come to court on time.
I just happened to have tweeted about this last night. So she has a YSL witness arrested for ignoring a subpoena. Yet she will dodge a subpoena herself from the Georgia Senate committee the same day. And look what we have found. We have found this flyer where she is, Matt, here it is. It says, "Stand with Black Women, HBC United. Join us in Washington, D.C. to honor and reelect Madam DA." Why does she have to call herself Madam? Anyway, Madam DA, Fani Willis, District Attorney, Atlanta Judicial Circuit, Friday to September the 13th. Which is the same day she was subpoenaed to appear before that Senate committee. So she's having a 2024 reelection fundraising reception. All contributions up to $3,300 are appreciated. RSVP is required to get the location in Washington, D.C. All attendees are subject to search. Reply by a text and phone to the number that she gives. So there you have it.
Oh, well, I should pull up too.
Well, this is a your political future in Georgia is over. Look to DC for future promotion.
Yeah, that's my
right.
100%. 100%. That's my take on it as well. 100%.
I get text message updates from, I guess, her campaign from being probably involved in her 2020 campaign. I just want to just briefly read something that I received on Monday. It says, "Rachel, this is Fulton County DA Fani Willis. I'm used to being constantly attacked and insulted, but this week may have been a new low for how the right wing talks about me and other Black elected officials. The right wing trolls are reacting to controversy, calling her a meritless DEI Shaniqua. Let me remind you, I am the DEI DA, and I will not let racist trolls tear me down." I mean, it just goes on and on. I just got this on my phone.
Just screenshot that and send it to me. I'm not on that list, but that's pretty.
I mean, turning it into this whole thing that it's really not. I mean, sometimes you do things that are wrong, and the power that you get, you just can't handle, and that's more what's happening. It's nothing to do with your race.
Yeah, and take it from me, a left-wing troll. I'm not happy with DA Willis either, and it started. It's not just YSL. It's her whole. It's so much of her conduct surrounding the investigation of former President Trump and the other people.
Well, it's not, to me, it's not really a left or right thing.
No, it isn't.
It's a fairness, right? You've got fundamental fairness issues. We all, regardless of whatever our politics might be, we all as lawyers, I think, should at least appreciate the fact that we've got to have a fair process. It's called due process, and it's got to be fair, and it starts with having a fair prosecutor.
Well, even beyond fairness, it's a matter of competency. I think her manner of pursuing the investigation of former President Trump, her hiring of Nathan Wade, etc., has just been sheer incompetence. And so, I mean, as a voter, I'm not a Fulton County voter, but I wouldn't vote for her.
No,
Thank you for saddling us with her, Rachel.
Oh yeah, and so the other thing is, like, I don't know if anyone watched. I think it was the Daily Show where Marlon Wayans. I may have mentioned this last time. There was this interview between Marlon Wayans and Nathan Wade, who apparently he got paid. I mean, it's pretty funny. He got paid to go on TV. Marlon Wayans is basically making a joke of everything, talking about like how he probably was like, screwing around with Fani in the office and the different positions that they had and all these different things. At that point, I mean, I expect her to be a little bit more angry at Nathan Wade at that point. But then, like, just a few weeks ago, she shows up at her daughter's arrest for some driving offense, and Nathan Wade is with her. And I guess he's been with her at many. I've heard that he has access to the office. I was talking to Ashleigh Merchant about the fact that we think that he's very often in the Fulton DA's office, and he has access to.
There's access to dogs.
Not my dogs today. My dogs are not here. Possibly a key card where he's like back in that office after he disrespected her so publicly about their affair. I mean, if anyone look up Marlon Wayans, Nathan Wade, and you're welcome.
Oh, it's her. Our Fulton County DA office right now is some weird, twisted combination of a joke and a horror. It's an embarrassment on a national level.
Yeah.
And actually, people overseas are seeing it as well. And this, again, it does not come from a partisan viewpoint. I think you've got a pretty full spectrum of political views over here on the left side of your screen.
Yeah. Well, you don't see
we're
Kamala
kind of in
Harris.
agreement.
You don't see Kamala Harris partnering with her too much either. I mean, I think
Not yet.
Well, I haven't seen it. I haven't seen it publicly. And if I
wait
I'm
till
afraid
later.
you're going to end up eating your words at some point, Rachel.
okay, well, we'll see. That would be a really big mistake for her. For
All right.
Well,
Kamala Harris.
all right.
So, all right, let's take a look at this. By the way, thank you all for the super chats. I saw a few of those popping in. There wasn't a question, so I didn't read it out loud to answer, but thank you all very much. That support helps the channel to grow and continue to bring content like this. Maybe you don't like it, but if you do like it, that's what helps. Thank you very much. So, all right, so this is the affidavit, okay, and this is the lawyer has filed this as he has to. This is standard affidavit stuff saying you're over 21, you understand what you're doing, you have what's called the mental capacity to say something under oath and testify, right? So you get basically, it's exactly the same since I've been employed since 2022 at the Fulton DA's office. Plaintiff, that's the DA, and they filed this motion, see docket. They filed an answer. Doug, this is what you were talking about. It's just more of the procedural posture, how everything happened. Hearings on June 25th. On July 12th, a motion to add defendants. I mean, standard stuff that we see. Again, it's just another recitation of, and they in an affidavit citing legal cases. I mean, I don't get it. They basically cut and paste their pleading and turned it into an affidavit.
And that, I mean, in my experience, the way I've seen affidavits attached to legal motions, they're often, when it's an affidavit done by the lawyer, they often are your factual recitation of your motion put into an affidavit format. That's not unusual. You don't normally see case cites in there. But again, I tell you what to do. Here's what, if you want to do something interesting, go back, and I know they're publicly available. Look at the affidavit that I filed I think it's my affidavit in the motion to recuse Chief Judge Glanville. Look at the appearances of impropriety that I cite in the affidavit, and look at how that's woven into my brief. Not that my brief is anything brilliant. I'm just saying, compare a more normal basis for recusal from this, hey, this is the best we could cobble together motion.
Well, I go through this affidavit. I thought, well, maybe there's going to be something in the affidavit that is an allegation of impropriety, and all they have is the Georgia Supreme Court is reviewing whether their district attorney is subject to the Open Records Act. I mean, the judge said that there's this issue out there that the Supreme Court may rule on or might, but until we get that, I'm going to have to rule the way I see fit. And so she did. And there's nothing about that that's ethically improper or demonstrates any, partiality in favor of one side or the other. I don't get it.
If she was asking and telling Fani that she had to turn over sexting messages between herself and Nathan Wade, I guess you could argue that, if she was asking them to turn over things that were unreasonable to have them turn over or something like that, or making a joke about those kind of things on the record, or suggesting that she thinks that Fani's unprofessional or lacks integrity, if those were the kind of things that were being said, it might be a little bit different. But suggesting that when you reach out to the Fulton County Open Records portal and none of the entities that should have access to the documents will provide them, there's nothing about that that's biased. It's just the truth.
It's just the truth. And the level of desperation that filing this motion goes to me, demonstrates there must be something that she really, really doesn't want to get out there. And again, you're doing so many, when you file a piece of crap motion, it's not just that you're going to lose. It's that you undermine your credibility. There's all kinds of secondary effects, as you guys know, from filing a bad motion. Because all you have as an attorney, right, is your credibility. That's all you've got.
That's it.
And it's a precious resource that should be spent carefully, right, Rachel? I mean, you guys know.
The way that she acts, and this has happened before, and we've got it going on with Sheriff Pat Labat in Fulton County as well, that they think that they don't owe any of the taxpayers and their voters and the citizens of Fulton County information about what they're doing with their money. It is backwards. And they say it like nana nana boo boo, I'm above the law and don't have to tell you. That's a horrible attitude as a public official. And it's offensive as people who pay taxes.
Yeah.
Well,
But,
so
you
what's
know,
next for this motion, guys? I mean, I'll tell you what I would do if I were the judge. I would say this is facially defective on its face. You have failed to make an allegation that would conceivably warrant, recusal. And if you don't like my ruling, file an appeal.
Yeah, I would say, okay, the motion was timely. Check, you did that right. However, even if I assume even if I assume all the facts that you've alleged are true, there's no appearance of impropriety that would warrant me giving this to another judge to make a ruling on. You haven't established under 25.2 and 3 the necessary facts for me to send this to another judge.
I would love for this to get to a judge like Kimberly Esmond Adams, who would just slam. He would slam them. I mean, so that's the thing. You think this is the appearance of impropriety? If you think that the way that Judge Krause handled this, this hearing and how she ruled, if that offended you, please, let's spin the wheel and get you a different judge in Fulton County. It's not going to get any better. I promise.
Someone did ask me if Judge Krause does decide that this merits being sent to another judge for making a decision on, could it end up with Judge Glanville?
Yeah, it could.
And it could, right? It could. Who knows?
They're randomly assigned.
He's petty enough to play tit for tat. But it could end up with him, whatever.
Well, I expect that. Look, I don't know this because I don't have any inside information. But I know Ashleigh and John Merchant, and if I know them like I think I do, they're probably putting the finishing touches on a response maybe as we speak. And I can't wait to see what that looks like.
It's just, again, it's all just so embarrassing. The fact that we don't have any of the records that we've requested, the fact that Fani, ignored the subpoena to go in front of the Georgia Senate committee. All I know is that what you would have said would have been incredibly problematic for your reputation, clearly. Otherwise, you would have said, this is how all public officials should be. I'm an open book. I have nothing to hide. This is what you did, and this is why, and this is how it helps you. But instead, you're just hiding and running from everything. And then expecting everyone to just think that it's because your lawyer told you to do so, and that your lawyer told you to do so after hearing what you would have said.
Well,
defense attorney, that's what that is.
Yeah.
So.
Go ahead, Doug. You're about to say something?
No, I'm just going to agree with Rachel. I have nothing to add to that. It's perfect.
Okay, we can all just go home now. Rachel's got it all. Got it all set.
Yeah, she does.
Hey, there was somebody, Michelle, posted a super chat, and this may be a message for you. I think it might have something to do with YSL. But thank you very much for the super chat, Michelle and everybody else. Putting witnesses up merely for the purpose of discrediting the witness or merely to lay a foundation for the witness to be contradicted on a material point and thereby rendered unworthy of belief was reversible error, citing Eberhardt versus State. I don't think that's an issue in this open records case that I know of, but it might be relevant to something going on in YSL. I feel like maybe somebody wanted you to get that message.
Well, I appreciate that message. I'll take a look at that case. If the DA's office thinks that they have done themselves any service by putting attorneys on for witnesses to testify in an effort to undercut the credibility of their former clients or current clients, then I encourage them to continue to do that in the future. If they want to put attorneys on to attempt to discredit their clients, if they think it went so well in the past with Mr. Wright, they were threatening to put up Ashleigh Merchant in the future. And I think that could be a reference to that. I don't know if you saw that. I don't know if you saw that, by the way, Rachel, but you would have loved it because.
Oh yeah, the little interaction between the judge and she said it didn't really work out so well for you last time.
Yeah.
And
By the way, for
Yeah.
those watching, I think we're shifted, and it's perfectly fine. I'm happy to
We have
spend some time
shifted,
talking
but
about
I thought that's
YSL.
where it
So
was going.
yeah, we're shifting into YSL, the Fani Willis versus Young Thug, and of course Doug, one of the defense counsel in that case. Rachel, an in-court observer frequently. So I think that's what we moved into. Sorry for the interruption, but please proceed with your discussion.
No. I think they should put Ashleigh Merchant on the stand. If they don't get the testimony that they want to plant in Martinez Arnold's mouth, if he doesn't say what they want him to say, they actually must do it. They must put Ashleigh on the stand.
I'll go.
And
I will be there
it's
that
such a
day.
critical thing for them to do in order to prove the justice of their case. They should put Ashleigh up there. And I just out of sportsmanship, I personally will not object to that.
Well, we should just have
I know they're
Ashleigh
always watching.
and Willis both testify. How about that?
Yeah, I mean, we've gotten so far removed. I'll talk about the YSL case as an observer. I mean, I try to keep up with what's going on in the courtroom. Really trying to understand what the crux of the case is. I'm lost. I'm so far lost. You know, we're talking about wiping noses and we're talking about Lil Wayne's tour bus, and I can't keep up with who did what. And then we've got lawyers that are being, put on the stand to try to discredit their clients. And the truth is that clients listen to their lawyers. So let's just say you signed that proffer, whatever that was, part of the plea agreement that Adrian may have switched up and made the original. She's sneaky enough to do these things. So don't put it past her. There's these factual allegations that in order to take this plea, that the last witness, I guess, had to sign and claim that, in order to keep his plea intact, that he had to agree with these things. It may have not been the final draft that the attorney and Adrian Love agreed on. But either way, if you tell your client to sign it, at some point, they're going to do it. And the fact that he got on the stand was if I was writing it myself, that's not what I would have written. The attorney isn't going to be able to save you from that, you idiot. And by you idiot, I mean Adrian Love, you idiot. I mean, it just looks so bad. And then you have to think that jurors, they're not allowed to ask questions, in front of this judge. But in other cases, Judge McBurney allows jurors to ask questions, which I kind of wish was happening here. They basically have to submit questions on paper at the end of a witness's testimony. I've had other cases
I hate
where,
that, by the way, I hate it.
I kind of love it.
Yeah, I wouldn't care for that.
Nobody likes that. I like it because I like to hear what the jurors are thinking. And when I had that competency case with Adrian Love, there was an attorney that testified on behalf of my client about his mental state. And one of the questions was, well, doesn't this violate attorney-client privilege? I think the fact that the prosecutors are putting lawyers in these situations where they're being asked to kind of testify about what their client did, there have to be jurors being this is not kosher. There's something about this that just doesn't seem right. And how can the lawyers weren't there.
Got a couple of super chats I want to address real quick. I want to come back to Michael in a second. Cat B Dog says, can anyone other than the DA's office issue an arrest warrant, or can she do what she wants? Judges have to issue any arrest warrants or orders for arrest. If you're referring to what we call a material witness warrant, that would be something presented by a prosecutor to a judge, and the judge still has to order it. It's not an arrest in the sense that somebody's being accused of a crime, but they're being held in jail to secure their testimony. But it always, whether you're talking about any kind of crime, it has to be a judge that does it based on some allegation that would warrant it under the law. So thank you very much for the question. Thank you for the super chat. But this was, Doug, you can weigh in on this if you want, or you can punt on it if you want. And I'll give it a crack. I'll give it a try first. I'm not a YSL lawyer, but the question is, did the YSL lawyers all realize that the evidence was a mess before trial? I think they knew that it was a significant case. I think they knew it was going to be voluminous. And, but I don't know that anybody could have foreseen it getting this bad. So I feel like the answer to that's probably a little bit, they knew it was going to be messy and it was going to be long. So crazy to litigate it on the fly, but that's how trials always are. You go into a trial and you've got a game plan, but then what happens is you're like, once the first witnesses, the whole thing just kind of goes nuts. I mean, it goes off
Yeah.
script.
I mean, I'm
So
happy to speak to this because they all came out in court. What happened in this case is we began trial, and by the way, trial began in January 5th, I think, of 2023. So we began trial only having about a third of this evidence that the state had at the time trial began. So we didn't have it all. As a matter of fact, we probably still don't have it all because stuff keeps coming to us. But we didn't have, it came out in tranches over the course of, say, January of 23 until late summer of 23. So we didn't have everything there. And the other thing was the state has done something that I've seen in civil, but not in criminal before, where the state has dumped all kinds of documents on us that are neither Brady material nor material they plan to use during trial.
yeah,
So they
want to keep you
basically
busy.
buried the evidence. And that is why, and we went through all this with Judge Glanville, begging for them to tell us what evidence they were actually going to be using. And it wasn't until we've got to the present judge, Judge Whitaker, that we have a judge finally say, okay, guys, give us a list of witnesses. For each witness, I want to see the specific evidence you're going to use for those witnesses. So it really wasn't until recently, which is astounding, since we've had a jury seated since December. It wasn't until recently that we got some specificity on the evidence that they would be using.
Which is crazy for preparation purposes to think that there's just kind of a steady flow or more of like a random dumping of new discovery. And what they'll do is that it's kind of like needle in a haystack where and I've seen this, where they'll send you like 1,000 jail calls. Some are other people in the jail using your client's PIN number to make the calls, and they won't specify which calls they are. They want to make it as difficult as they can and keep you as busy as you can doing anything other than preparing the defense based on what the evidence is going to be. And that's that has been Adrian's strategy since I've known her. I had several other cases before. I had another case against her that actually Brian Steele's handling on appeal. She pulled the same thing, giving us evidence the day that we're starting trial. And there's rules about this. You're supposed to have all the evidence 10 days before trial.
10 days.
And in my opinion, and if you're going to be a judge that's going to keep things fair, anything that wasn't turned over before the trial, it should not come in, period. Yeah. But I still, Judge Whitaker, I do like her attitude towards Miss Love. It just seems a little bit more fair, but she's still not really keeping anything out. And so again, there has to be actual consequences. Otherwise Adrian's going to keep doing what she does.
Doug, I know you have a shindig that you're getting ready to go to, so I don't want to keep you too much longer, but this is a great,
make me look pretty.
This is a great question for you, Doug. If you want to, what would happen to the state's case against the other co-defendants if they fail to convict these that are on trial now? Anybody want to take a swing at that?
These geniuses,
what do you think they're going to do? Yeah,
I think they have, again, in the same way, there's like a lack of, they can't read the room. I think they would go forward or pretend to go forward or until they can work out pleas, possibly. I think they're going to go full force against everyone that they can. Again, although these individual prosecutors are not paid significantly more money or anything by handling these cases or being on them for a long period of time, the more attorneys that you could and resources that you could put towards these cases, the more money you could argue you need grants for to hire other attorneys to take up the cases that they're not able to handle because they're stuck in these cases. So I think go as hard as possible.
I mean, ADA Love, or she's not an ADA, I don't know her official, Deputy DA Love.
Chief person.
Chief Deputy DA Love. She is a bulldog, and she is stubborn.
Beast.
And she is going to plow ahead, I would bet, regardless of the outcome of this case. Maybe she will I'm not going to assume she's going to learn from this case to do a better job next time. But
no shame, shameless.
I don't know. I think any change in the posture of these cases is only going to come from higher than Miss Love.
Well, so that would be Willis herself. That would have to be the one to pull the plug on it all. But I think if they can't secure a conviction, I think a reasonable prosecutor would say, well, if we can't convict these, then maybe we need to rethink the rest. That's just my
agree
opinion.
with you 100%.
That's what they should do. That's what they should do.
Yeah.
But again, just like she should just have recused herself from the case and been done with it with the Trump case so that it could have moved forward and there could have been a prosecution within a reasonable time if it was actually if there was a basis for it, it should have happened. But they're so busy protecting their own interests and power, they lose sense of justice.
But you know what? Put all that aside. As someone that used to be heavily involved in politics, if I was the DA and I lost this case, what I would do with the others is I would plead them out to some form of time served or who knows what, get guilty pleas on something, call a big press conference and talk about your huge victory. Declare it's like Russia should do in Ukraine, declare victory and leave.
Except they scared the shit. Pardon me, they scared everybody about all these people on Cleveland Avenue, and they made them seem like they're all the scariest people alive. So they just let them free.
Well, they scared all these people, but then they pled how many out?
I know,
for time served and probation and put them right back out on the street.
Doing the same thing.
And that's what I argued in my renewed motion for bond. Don't take anything the DA's office says as gospel about how dangerous Diamante Kendrick is, because they said the same about all these other guys, and then they just let them out on the street.
Yep.
Come on.
And they're okay. They haven't hurt anybody since. Exactly.
All right, Doug, I know you got to go, buddy. Doug's got to go. Rachel, you can feel free to stick around. I'm going to answer. Doug, thank you. I'm going to let you go. I'm going to answer. We got some supers I'm going to address. Everybody, big round of applause. And Doug, you need to behave yourself tonight. I think you might be in Atlanta. And
I'm not driving.
Well, I mean, it is. It's Fulton County, buddy. I'm just saying.
Driving. I'm not driving.
All right. Have fun, bud. All right. So is it illegal, Rachel, for an officer to be married to a witness?
I don't know about illegal, but they should probably recuse themselves if they're investigating the case. My understanding, I was on Twitter today, and I noticed that people were saying that maybe this Quindarius, I think that's his name, there's someone who got arrested. He was at the hospital. He has some kind of serious illness, and that they took him from the hospital on this material witness warrant. Apparently, his aunt was married to, this is what this is alleged because I can't not confirm, but his aunt, who he lived with, was married to Detective Gaither. And Gaither was living in a house with one of these witnesses. So I think the question is now, like, this is all happening under her nose. How is he? I don't know enough about his involvement in this case or what they think he's going to testify to, but it's all very incestual.
Well, it's not literally, but it's, but yeah, no. I mean, your points, it certainly is fodder for great cross-examination. So I'm very interested to see how that plays out this week. I'm going to look forward to getting Doug on the back end of that one as well, once it all plays out. Thank you very much for that super chat. Now, Michael asks, God forbid, how would appeal work? Would each defendant file on their own or just one huge appeal? So this is, I think, about YSL. So first off, you got to understand, you got to get through the trial first.
And the transcript. Oh my God.
How long, Rachel, to prepare the transcript on this thing? I mean, God almighty, I can't even begin to imagine, because you see the court reporter taking down all this stuff, right? And then there's also an audio recording. They've got to go back and they have to convert that. Even it might be done by a computer. They still have to proofread it and maybe compare it to the audio and then generate the official transcript.
All the exhibits have to be in there.
You got to include all the exhibits for the record and all, and so each lawyer then, so once after 3 or 4 years, when you get a transcript that's ready, each lawyer then is going to have to go through, or the appellate lawyer anyway, because each person's going to have a different lawyer for the appeal. So one of the things that have to look at on appeal is whether the lawyer at trial was effective or not. And so it has to usually be a third party or a separate lawyer who's not the one that did the trial. So then they have to read the transcript, and they have to imagine reading the transcript of this entire case that takes years to finish.
Yeah, like a 7-day trial or 6-day trial usually is a few, like 2,000 pages.
Yeah.
Um,
This is millions of pages, I'm sure.
Yeah.
Before. So you got to read through it all. You've got to identify the legal issues that you see. You got to do legal research on that issue. And then you got to prepare a brief and all this. So they all are separate. They all have their own counsel. So the appeals process is just something just unfathomable to me. I can't.
They have the right. Well, they have the right to appointed counsel on appeal as well. So if they can't afford counsel on appeal, then the state of Georgia has to pay for them to have an attorney, an appellate attorney, to handle their appeal. So if you could just imagine how much more money that would cost. I think you and I both don't think that we're going to be in a situation where the jury is going to convict these individuals. But yeah, if they do, we're talking about another 10 years at least of litigation.
I don't, this is part of why, and this is not really what the question asked, but I'll just inject this. I think there's a significant constitutional problem with the prosecutor who creates a trial that's this large. Not to mention the fact that you've got the jurors that are held captive for years on end, but the fact that you can't reasonably expect lawyers to go this long, right?
Right.
It's just not sustainable. And then you have a constitutional right to an appeal, but if you make the appeal so just ginormously big that you just can't, no lawyer can tackle it, you effectively have denied the defendant then their constitutional right to an appeal. That's
And
my
right
take.
to a speedy trial. So think about the fact that, you're supposed to have a trial constitutionally more or less within like a year of it becomes presumptively prejudicial for a trial. Hello, doggies. For a trial to not occur for someone within a year of their arrest in Fulton County. Hello. That's very cute. That's not something that really ever happens. So let's just say like 2 or 3 years down the road, but now we're getting to the point where just because you start the trial, you still are denying them in my opinion, you're denying them a right to a speedy trial by taking 2-3 years to try a case because they're sitting in custody the entire time. It's a lot harder to make that argument if they're out on bond, which I still don't understand. These are individuals who, most of them have community ties. The ones who aren't already convicted of murder, which is I think most of them, the fact that they can't sit at home on house arrest with an ankle monitor instead of having them in these jails for the years and letting them wear whatever they want. I mean, the fact that they're all in custody, I know now they're talking about how they can only have a few different outfits. It's so much harder to work with your attorney, as an attorney to work with somebody who's incarcerated in preparation for trial. If they were out like on the weekends, you could like sit at a table together at a coffee shop and actually get things done.
Yeah.
So, yeah.
Well, that's just, it's great comment. That's just insane to think about. Capstar says the judge self-recusal. So we're talking, I think that's in reference to her motion, Fani's motion to quash the Senate subpoena. So what I understand happened, so she files a motion to quash the subpoena, and it's filed in Fulton County because that's where the seat of government is. That's where the Senate's located. So everything's in Fulton County. So I think the rest of the question is it due to a conflict of interest or because of fear of her? I don't think it's because of either of those things. I think it's political expedience for them because even though they're technically nonpartisan, all judges are elected. And this thing is charged politically. Okay. You've got the Democrat DA and you got the Republican Senate, and you got the Democrat former governor. So and then some of these judges may have even been appointed by Roy Barnes. I don't remember, but the point being, it's just the easy way out. And honestly, I do not blame them. I would have done the same thing. I wouldn't want to touch this with a 10-foot pole probably. And so it's any litigation between like DA's offices, these kind of things, they're oftentimes farmed out. And by that, I mean to a retired judge or someone in another county for political expedience.
Well, Judge Krause actually was the one that got Glanville recused as well. So she's kind of been in the middle of both of these of Fani's case with Trump, and then now and the YSL case, because after a few different judges recused themselves from the motion to recuse Judge Glanville, Judge Krause took it up and was the one to actually recuse him. So she's, I have a lot of respect for her for being willing to take these, kind of hard cases where you have a lot of political pressure from the DA's office or your colleagues on the bench and saying what's right is right. And I think she's doing the best that she can, but we're seeing the antics that some of these these entities are playing, all to avoid their own exposure and transparency.
Yeah. I mean, I'm surprised that you and I talked about this. We may have talked about it here on the show. I mean, when there was these motions to recuse Glanville and he decided he was going to send it to another judge, you and I think most of us who are observers thought, well, there's no other judge in Fulton County that's going to send it out just like they did this one. But no. And some of them did actually. It did bounce around before it landed with Krause. And then the appointment of a new judge that actually bounced around, but due to some self-recusals before it stayed with Whitaker.
It's crazy. This is fun.
Yeah, Michael Lawless, the jury will need bingo cards for deliberations to track all the charges, elements, and defendants. Rachel, when we have trials, explain what he's talking about, because I think we both know the answer. I'll let you can go first.
I mean, you just usually you have a case, like one murder case. It's a week long. There may be several charges. And each charge has elements of the charge, meaning the state has to prove each element of a specific charge beyond a reasonable doubt. Usually you're dealing with one defendant, maybe two defendants, maybe, 5, 6 charges. In the case the YSL case right now, we've got, I don't even know how many charges that they still have left, but just to think that this jury after all this time are going to be able to say, how can I give individual consideration to this defendant when I don't even remember talking about this defendant. I don't even know if they could tell them apart with flashcards. They may be able to say, yeah, that's Young Thug, Jeffrey Williams, but who are the rest of these people? It's going to be incredibly difficult for them to organize. It's hard enough for a jury to organize several charges for one defendant. We've got 6 defendants. And the state is purposely trying to muddy the waters, kind of saying, well, they all worked on Young Thug's tour together. So now apparently they're all gang members and they're all guilty of what each other did. So it's just interesting. Mike Lawless, I do not envy them, but I do think by creating this monstrous, web of a case that's just going to be impossible for them to do that, I think that ultimately benefits the defendants.
Well, it's a mess. I've said this before about the YSL trial, and I'll say it again, and I'm sure I'll say it more times in the future. It's too big. It's a little smaller than it was when it started out, but it's still too big. The courts can, for all the reasons that we've been talking about, and then some, courts just cannot digest that. It's like trying to eat an entire side of beef in one bite, right? You just can't do it. It's not something that you can digest. It's not something that's, it's just too big. The courts literally choke on it. And I think that's what we're seeing. I'm surprised Judge Whitaker has not taken any of the many opportunities she's had to grant a mistrial. Aside from the fact that I think it was legally the right thing to do, it would certainly prevent a lot of these problems from popping up in the future. And it would have, I think, righted a good bit of some wrongs here. Just my opinion. I welcome yours.
I'm just enjoying the comments.
Yeah, listen, this is the best chat. I love
really
the chat
is.
here inside the law. And by the way, I go back and I try to watch the replays on these videos, and I do look at what folks have to say. I miss it because I'm sort of speak, driving this thing. I miss a lot of it, but I like to go back and watch. Yeah, the folks here in this chat and on this channel are really, really impressive. And I thank all of you. We've had at one point, we had, I think 4,000 people in here live. I'm very humbled by that. It's a testament to everybody's interest. And I think, this is all stuff that the public at large has a lot of interest and curiosity about. So Rachel, I want to just say thanks to you, by the way, for spending another part of your weekend, Saturday, I guess, here with us. Any closing remarks, closing statements from Rachel?
I just can't wait to see what happens next. I'm very excited for appellate arguments. That when are they coming up at the Court of Appeals?
On her recusal, or on her, the boot to recuse Willis off the Trump case. Yeah, that's in December now.
They keep pushing that back. I cannot wait for that. We'll get our popcorn ready. I'll be very excited to hear that. And I just thank you everyone for your support. And nothing feels better to me than feeling like other people understand now just my personal anchor towards Adrienne Love and where it comes from. And it just feels good to have people commiserating, because for so long I kind of felt like she just got away with everything. And I feel like that's not going to happen anymore, other than Dwayne in the comments. Yeah, I see you. So anyways, thank you. And we'll see what happens. And everyone go check out Marlon Wayans and Nathan Wade if you want a good laugh.
All right. Big round of applause. Happy weekend, Rachel. We'll talk to you next time.
That was
all right. And look, I want to say thanks to all of you guys. We're going to have to kind of leave it here, but whatever you do, I just want to leave you with one parting idea. Whatever you do, don't be this guy.
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lies.
Yes, you may. We're gonna take a break. Hang in there.
We're going to leave it there. Thanks, folks. And we'll see you back here next time inside the law.